The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. 3 cases are submitted this afternoon. Those cases are City of Eagle Grove versus Cahalan Investments. Second case is in re the detention of Nicholas Weigel. And the final case is in re the detention of Ronald Tripp. The Tripp case is now submitted to the court without argument, and we'll proceed to hear the arguments in the City of Eagle Grove case. Ms. Seaba.
May it please the court, counsel, my name is Lynn Seaba, and I represent the appellant, the City of Eagle Grove, in this case. This is an appeal of a district court dismissal of the city's action for an award of title to 2 properties pursuant to Iowa Code Section 657A, 10A, subsection 5. These properties, located within the City of Eagle Grove, Iowa, are owned by the Appellee Cahalan Investments, L.L.C. The subject properties consist of abandoned houses, which have been unoccupied for more than 10 years. One is located along the central commercial corridor of the city, and the other is located within a residential district in close proximity to a group home for disabled adults. At trial, the district court determined that both properties met the statutory criteria for abandonment under Iowa Code Section 657A, 10A, subsection 3. At that point, the City of Eagle Grove, Iowa, should have been awarded title to the properties. Pursuant to Section 657A, 10A, subsection 5, once the city has proven that the property is abandoned, the district court shall then enter judgment awarding title to the city. After an award of title, the city can demolish the buildings, clear the lots, and convey the property to subsequent buyers, free and clear of all liens. This statute gives the city marketable title, as opposed to other statutory remedies for abatement of nuisance, which would merely create a lien in favor of the city for its cleanup cost. In this case, the district court did not award the title.
I don't think there's any question the statutes allow them to take possession of the property, but the question is, does it become a taking?
Yes, the issue in this appeal is whether or not Iowa Code Section 657A, 10A, subsection 5 is an unconstitutional taking of property in violation of the 5th Amendment of the United States Constitution and Article 1, Section 18 of the Constitution of the State of Iowa.
Well, why isn't it?
It's not a regulatory taking because in this case it's a legitimate exercise of police power.
Well, but the total title is taken. I mean, ordinarily, as I look at the cases, when there's complete and total deprivation, that tends to be one of the talismans or one of the characteristics of a taking ordinarily.
And generally, Article 5 of the United States Constitution and Article 1, Section 18 does direct that we don't take private property without just compensation. However, this court and the United States Supreme Court have recognized the police power exception. And in Waterloo versus Bainbridge, this court recognized that the condition created by abandoned buildings is an evil that should be remedied by Section 657A, 10A.
But that wasn't a constitutional question there.
No, specifically the issue was presented to the court, but the appellants in that case had not preserved the issue on appeal, and the court did decide that on other merits and did not address the constitutional issue.
Well,
this case today has it before the court.
Here's a quote from the Lucas case, the United States Supreme Court case. And it says, a regulation that deprives a property owner of all beneficial use of property may be a taking even if it is a valid exercise of police power. A property owner expects restrictions of some uses in the public interest, but regulations that deprive a landowner of all beneficial uses are taking unless under the relevant background principles of state property law, the property owner would have no reasonable expectation of being allowed to use the property. Now in Lucas, the Supreme Court's basically saying, we don't have to even take title to your property. If we put so many restrictions on it that you can't use it in some reasonable fashion, it's a taking, even though it's under the exercise of police power. So I don't think you can say the police power in itself. A valid exercise of police power gets you out of the Fifth Amendment.
Well, and I think in the Lucas case, if you're talking an innocent property owner who has not created the conditions on the property which resulted in the action taken by the city, that would be a distinction in this case. In the case at hand, we had abandoned nuisance properties which were creating a nuisance for other residents within the city of Eagle Grove, and the property owner took no action.
But the Supreme Court has only said property taking, and it was a 6-3 decision, by the way, property taking as an instrumentality of a criminal act is not subject to the Fifth Amendment. They've never said taking pursuant to a civil action is not a taking.
I think that Blumenthal Investment Trust, which versus West Des Moines, which was decided by this court, tells us that if it was an arbitrary and unreasonable action, then we would consider it a taking, and in this case, it advances a legitimate state purpose.
Here's the line of cases that I think may be potentially applicable, and I think the Minnesota Court of Appeals in an abandonment case cited it recently. In Texaco versus Short, the U.S. Supreme Court upheld an Indiana law that provides that certain mineral interests forfeit to the state at some point if they're deemed abandoned, if the property owner doesn't do things in order to properly demonstrate that they haven't abandoned them. Is that kind of essentially your argument? Is that the position you're arguing, relying on the Texaco versus Short line of cases?
I believe that rationale does apply here, because in this case, the property owner did not take action that was reasonable to retain his interest in the property despite
Given
notice.
what kind of notice were they given? What does the record indicate as far as you better start doing something or you're going to lose this property?
He was given written notice by the city of Eagle Grove prior to the filing of the action in district court. And he was given 90 days, and then the case did not come for trial for 12 months subsequent to that notice, and during that time period, no action was taken to remedy the problems with the property.
In this situation, though, you had the option, though, of cleaning up the nuisance yourself, tearing down the property, and doing that, you could have put a lien on the property for the cost of doing it, and if the lien wasn't paid, you could have foreclosed on the property, all of which you didn't do. You just want to take title to the property.
And that's true. And that remedy has existed, and it existed prior to the enactment of 657A10A. The problem with that approach is when you have a lien, you're going to receive a lien on the property that would then go on tax sale with everything else. And a tax sale certificate holder would have to wait 1 year, 9 months before they could apply, give a 90-day notice to the property owner that they intended to take deed. Then they would take deed. So 2 years now have passed, and that abandoned condition has not changed on the property. It's continued to be a nuisance to the city.
If you tear down the building and clean it up and just leave it as a vacant lot,
Well, I guess that's true in that case, but they can't market it, so they can't recoup their cost, is essentially what's happened. They've held on to that property, and they've no longer, at that point, the city is stuck with a big expense. It's not a marketable title. It's going to be 2 to 3 years before a tax title certificate holder takes
well,
an
that's a
actual
legislative
deed.
problem. I mean, you can go to the legislature and get it fixed, but you can't say just because it's inconvenient, the Constitution doesn't apply. If that's the case, the Constitution wouldn't apply to a lot of things.
Well, I don't think it's a matter of convenience as much as it's in the best interest of the city to take title free and clear, so it's a marketable title so they can
It's the
convey
best
it.
interest of police officers to search cars without probable cause to look for crime. But we don't let them do it.
Did the Court of Appeals address the constitutionality of this statute in the City of Monroe case, and should we be persuaded by that?
I apologize, I don't have the exact circumstance on that case right now. But I do believe that this court has looked at it in Waterloo versus Bainbridge, as well as Harlan and Rogers is the other case that this court has reviewed the statute. The history of this statute, it actually came to be Senate File 2291, and it was an act relating to local government authority to encourage development and rehabilitation of certain property. And it was part of an act along with economic development, and the legislature was trying to give cities a vehicle with which they could rehabilitate blighted areas within their cities. And that's all Eagle Grove has been trying to do here, is to rehabilitate a blighted problem that's within the city of Eagle Grove.
These are properties with no utilities.
This property has no utilities. It's been vacant, has been unoccupied, one of them more than 10 years and one of them more than 15 years. The record is de novo. You've seen all the pictures of the property as well as the testimony of the neighbors as to the condition of the property, and there was no doubt, nor is it an issue on appeal whether or not these are abandoned under statute. It's just simply, is the abandonment taking title to the property through this statute an unconstitutional taking of the Cahalan property?
Well, is there any type of balancing that's done here under the statute? You know, the way that I look at it is the statute's pretty much presumed to be constitutional, and so you have that presumption going for you, but then you have you know, the rights of the city to exercise its police powers, I believe, in order to protect the health, safety, and welfare of the public overall. How does that balance against the private property interests of the defendants in this case?
The Kelly versus Story County gives us a three-factor test that we can look at. It's a case-by-case test when we're evaluating it. First, we need to look at the economic impact on the claimant's property. Secondly, we look at what regulation, if it has interference with the investment-backed expectations of the claimant. And finally, what's the character of the government action? And this originates in the Borman case, this three-factor test. In this particular case, the economic impact of the property and the investment-backed expectations, if the court will review the record, you'll see that the defendant really had no intention in any time in the near future to rehabilitate the property, and really the city was essentially eliminating a nuisance and taking care of a problem for this property owner. He had mortgages against the property and other liens and did not have the financial resources to rehabilitate the properties to make them habitable. He had these properties, both of them, well in excess of 10 years and really didn't have resources to do anything. And so at this case, there would be a limited expectation of any investment recovery that the defendant would have had in this. And certainly the need of the city of Eagle Grove to eliminate these properties from their town, one in close proximity to disabled adults, and there are vermin running in and out of the building, and the other right on the central commercial corridor, far outweighed any harm that would have been done to the defendant.
I guess I'm just going to ask a question. How is this different than a tax sale when you don't pay your taxes and the county can come in then and put a lien against it, of course, and then somebody else can come in and buy it and take it over, and the property owner in that case doesn't get any economic return on their property either, do they? And so how is this different from like a tax sale or any other? Okay, I'm trying to think of another device that you could use in order to obtain title, because people get titles to tax delinquent property all the time as well because the owners have effectively abandoned the property.
They do, and I don't think that ultimately, as far as the property owner's perspective, there really is any difference, because the owner will lose title to the property by not taking action.
Doesn't the owner have a right to redeem?
The owner does have a right to.
The owner has a right to redeem before it's actually sold.
Yes, they receive 1 year and 9 months in, they'll get a 90-day notice that they have a right to redeem that property. And in this case, the owner here had a 90-day notice to take action to clean up the property, and then another 12 months in which the case was pending before the district court and efforts were made towards take some action. There were settlement negotiations, and there, within the court record, it shows where there were attempts made to work with the property owner, and the city of Eagle Grove has done that with many other property owners. If some effort had been made, he would have a chance and opportunity to keep his property. But in this case, the defendant testified that he had no intention in the foreseeable future to remedy the problems with the property. This remedy has been utilized by City of Eagle Grove and other cities within the state of Iowa to successfully abate nuisance properties within their jurisdiction. It is separate and distinct from taking a private property pursuant to eminent domain. The City of Eagle Grove has absolutely no use for the property, and the award of title is not considered an exercise of eminent domain. The action brought pursuant to Iowa Code 657A 10A is an appropriate exercise of police power of Eagle Grove to regulate the property for the health, safety, and welfare of all of its citizens. When this court recognized in Waterloo versus Bainbridge that the condition created by abandoned buildings is an evil that should be remedied by 657A 10A, I think the court has recognized the validity of this statute and the proper purpose where good does outweigh the harm to the defendant in this particular case. Thank you.
Thank you as well, Counsel. Mr. Eide.
May it please the court, Attorney Seaba. I'm Eric Eide. I'm here today on behalf of the Appellee Cahalan Investments, L.L.C. And my client is asking this court to affirm the trial court's decision that found that Iowa Code Section 657A.10a is unconstitutional and that it effectuates a taking of private property without just compensation in violation of both the federal and state constitution.
Can there be an unconstitutional taking of a property when that property has been deemed to be abandoned?
Yes, Your Honor.
And explain how abandoned property can constitute a taking.
Well, I mean, there's a difference between abandonment and ownership. I mean, if you mean under 657A, there's factors that the trial court went through and found that this was abandoned under this statute. But that doesn't mean that it's not owned or claimed by the, in this case, the defendant, Cahalan Investments. And so I think that, they still own the property.
Well, if it in fact was abandoned, if everyone agreed it was abandoned property, would there be a constitutional taking if the city took the property?
Yes, I think that's exactly what we have here if your definition of abandonment is how it's defined under 657A. I mean, this property wasn't abandoned in kind of the common vernacular in that my client was still there. My client opened the door for him when they took their inspection. So it wasn't abandoned in that context. So he still owned it and expected, he was trying to sell it, in fact, when this came up.
This is a facial attack on the statute. You're not arguing, this isn't an as-applied attack. You're just saying the statute's flat out unconstitutional, right?
Yes, Your Honor.
Well, Counsel, you would agree, would you not, that there can be a taking by a government under the police power without compensation in some instances? I mean, Lucas sort of makes that pretty clear, I think, in the discussion of takings jurisprudence. Isn't this just a question of whether the condition of these two properties was so bad that the police power justifies the taking without compensation? Isn't that really what this case is about?
No, I don't think so. I think that there's you either have a taking or you have a police power action. I mean, that's the distinction. You have to fit into one of them.
Nice distinction. But isn't the question here whether these properties were in such dilapidated state that the police power justifies the statutory-based action in this case without compensation? That's perhaps a more accurate way to say it.
Right, that might be what the statute provides for. It's a little analogous to, there's an Iowa case where DOT had a billboard that they made him remove. If the question was just making him remove this property under all the different alternative remedies that are available, then I would say yes. If the city of Eagle Grove, if you've probably read the record, they have a fairly common dangerous building statute that allows, as you guys were discussing earlier, they allows the city to go in and do the work and then assess it back as costs and collect it through the tax process. If someone wanted to argue that that was a taking, then you're going to have that, what you're just bringing up. That's going to be the police power versus the pure taking. In this case, where you're just appropriating fee title, it's well beyond any police power. And this is a classic
What do you
case.
do with laws that say, like, if, you're on some list of unclaimed property owners list, and at some point, if you don't file a claim and say, I want that property, then it escheats to the state? Are those unconstitutional?
Yeah, I don't know, Your Honor. It's more of the, it's maybe more in line with the forfeiture cases. And now the forfeiture cases deal with an underlying criminal conduct.
I mean, and don't you think that maybe Texaco, the U.S. Supreme Court's decision there, provides maybe an analytical framework where they say, abandonment coupled with notice to the property owner can justify the state in taking ownership of the property.
Yes, I do think that would be provide an analytical framework. Again, it comes down to how you define abandonment. For our purposes today, we're looking at 657A's abandonment. And again, my client didn't abandon these properties. I mean, he's there on a...
Client pay taxes on the property and do those things? Or?
Yes. I think he was delinquent on one at the time of trial, but
he was paying taxes all along?
Yes.
I think the record shows he was delinquent on both when the action was filed, but in the interim between filing and trial, one of the two properties was brought current.
So I think that framework depends on how you define abandonment.
You think of that opinion by the Court of Appeals a few months ago that they published, dealing with the same constitutionality, the same statute, the City of Monroe
I think
case.
you're talking about Justice Waterman brought. I mean, I think it was wrongly decided. I mean, with all due respect, if you read some of the comment or the opinion itself, it says, "We note the exercise of police power may amount to a taking if it deprives the property owner of substantial use and enjoyment of the property." And what we're talking about here is not just substantial use and enjoyment. This is the full bundle of sticks that we're losing in this one. And I think the Court of Appeals misstated the law when they talked about, even in the event of a complete taking, the state is not required to compensate a property owner if they can show that the bundle of sticks never included that right. And I just think that's a misstatement of the law.
Well,
and they didn't have the benefit, quite frankly, of Justice Appel and that Brackey decision where you outlined all the taking analysis.
With respect to the bundle of sticks framework, the city's position, and I think perhaps the legislature had in mind, the notion that a property owner, an owner of a residential property, does not have in its bundle of ownership sticks the right to leave a property in a dilapidated and dangerous condition. So how do you respond
and you can
to
take
that?
you can take that stick if you want to. You just have to do it the way the Constitution allows. So again, they could come in there, the city, and they could follow their own ordinance that's been in place for years and years, which is backed by statutory authority under 364.12, and they could get a court order, remedy that, assess the cost back. There's a lot of alternatives here. They can go to a municipal infraction, get a personal judgment for the cost of that.
But in the
If your client did have an intent to abandon this property, would the state have to pay compensation?
You're kind of getting me back into what Justice Mansfield about, the definition of abandonment. But, and again, Your Honor, most of the cases that are actually brought out in the state of Iowa under this, the abandonment is never, people don't show up for these. That's why it's taken a while to work up to this court. They really are abandoned in the sense that people have no interest in them anymore. And so I think that's the difference. But again,
well, are you challenging that the test of abandonment using the 13 factors that the legislature set out is an insufficient test to determine whether or not property has been abandoned? I noticed intent is not.
Yeah, the court's already ruled that intent isn't a factor that we can take into consideration. I'm not really challenging that whole, that part of the statutory framework. I mean, if that's what I think it'd be better named nuisance buildings, if you ask me. But that really isn't important for what we have here today, whether it's abandoned on those statutes. Because regardless, even if the intent, if you could establish that the intent was to abandon, say they didn't show up, you still have the same analysis, I think, constitutionally. You still owe them compensation if you're going to take their property.
The Supreme Court said in Texaco, "From an early time, this court has recognized that states have the power to permit unused or abandoned interests in property to revert to another after the passage of time." Now, we would agree at least the properties were unused, whether your client subjectively intended to abandon them. They weren't being used, right?
That's true. And again, it goes back to the reason that I wouldn't have a problem if they were just to go and tear down the property and assess that cost back. You still have the land. And I think that's what most people, when they see this, is how can you take the whole property? If you want to fix the nuisance, fine. Abate it, assess me back, sue me for a personal judgment. But you can't take my property, including the land.
Well, but that gets us back to the prospect that I think the legislature was trying to avoid, which is saddling the city with that expense, which will not be recouped. Let us suppose that there are a lot of these dilapidated and dangerous properties in small towns, and the lots themselves aren't worth the cost of the demolition. And so what troubles me with your analysis is that it's transferring the cost of these problems from the property owner to the city, because the city pays to demolish, taxes it against the property as though it were real estate tax, and never gets it back. So,
It kind of goes back to what Judge Wiggins, I mean, believe me, it's a very powerful remedy for cities. I mean, they're all using it. Nobody's using any of the other alternatives because it's so fast and so powerful, but it's not constitutional. That's the issue. Yes, it's cost a little more. I mean, they could condemn the properties if they want. I mean, the legislature specifically identified this type of property to open the door to condemnation. They could negotiate a purchase, and that didn't happen in this case. And that happens, I mean, in the world prior to most condemnations, there's a lot of serious discussions. When you know that the acquiring agency has the club of condemnation, it usually is kind of a leveler when it comes to negotiating, and that really wasn't.
But in this case, they're not condemning property for the public good. All they're trying to do is to clean up a dilapidated, dangerous building that your clients created. So it's not like the city is going out there and trying to negotiate that they want to purchase this property so we can do it for the public good. I mean, it is the public good because it cleans up a dangerous building, but I don't see where condemnation really would apply here, because we're not taking it for a public good, such as a road or anything else like that.
It's a little different than the typical condemnation where you have a public improvement. But again, the legislature in 364-12A specifically said that cities have condemnation power to take nuisance properties and to recycle them basically into productive use.
Were these lots worth less than the cost of demolition?
The record doesn't show that, Your Honor. I know what the cost of the lots were, but there was never any evidence about what demolition costs were.
I thought there was evidence in the record that showed that it'd probably be $10,000 to $12,000 for each of these lots to be cleaned up.
There may have been some testimony on that, but there was never any, I guess I would say, expert testimony of these particular properties, kind of a ballpark of taking properties down in general.
I'll tell you what my concern is on, if we would declare this statute to be unconstitutional, it sounds to me like anybody or a sharp individual could always come in, buy themselves dilapidated, dangerous buildings, and then, without any remedy available, such as this statute I think provides, simply turn around and say, okay, you city have to buy my property from me. And so you almost do it as an investment. You buy it for $2,000, you say it's worth $10,000, and I want you to pay me the difference because this is an unconstitutional taking.
Well, Your Honor, if I was city attorney and I couldn't use this 10A, in your situation, I could sue them for personal judgment. I can go in and remedy whatever it is that makes it dangerous or a nuisance. And I can either assess that back and collect it as taxes, and cities have a priority in redemption. They reduce the redemption period to 3 months to try to encourage that. Or I can go under a municipal infraction and I can get a court order to remedy the situation, and if that isn't effective, I can go in and get a court order for personal judgment for the costs of it, or go on taxes. So I have 3 remedies there.
Yeah, but
other than
isn't this just another tool that the cities ought to be able to have in order to remedy this problem of dilapidated and dangerous buildings?
I don't think so. It's unconstitutional in the sense that it goes too far. It takes, and what I hope the court does is, the Borman case lays this out, the analytical framework, very straightforward. You just have 3 questions you have to ask. Is there a protected property interest, which again, in ownership of property, I think that one's not debatable. The second one is whether there's a taking, and that's typically where your debate comes in. And in this case, again, you've got, again, what I would call a classic per se taking, in that you've got a full appropriation of the rights in the property. And then the third one has to do with whether there's just compensation, and you have to have just compensation if there's a taking. And the trial court, in 4 paragraphs, based on those Borman factors, was able to rule this statute unconstitutional. And frankly, the Borman statute, I think, was a little more difficult, and this court found that to be flagrantly unconstitutional. Thank you.
Mr. Eide, let me ask you a quick question before you sit down. If this statute included personal property, like abandoned vehicles, for instance, would you have the same argument that it would be unconstitutional for the state to take an abandoned vehicle located on someone's property?
That might be closer into the police power, Your Honor, but I mean, again, the Constitution doesn't distinguish between real, personal, mixed property. So you're going to have the argument about whether it's a taking. And when you have the cases where they find it is a police power, let's say the billboard case, diseased animals, the zoning cases, usually they're able to show that there's, I won't say an emergency, but there's an exigency out there that requires some summary action. That's what this is. It's just a summary for a condemnation. That's what this statute sees. I don't think the emergency is out there in these cases.
Thank you.
Thank you.
Seaba, rebuttal?
Thank you. The record that was submitted at the district court and admitted, land value on one of the properties, the bare lot, was $5,400 according to the Wright County assessor. The land value of the other property was $8,900. That's the bare lot value. There was evidence presented from a local contractor on the demolition cost, and the one property that was lot value $5,400, demolition cost $10,999. So on that property, yes, in fact, the demolition cost exceed the economic value of the lot. On the other property, demolition cost, a bid was $12,000, $117. The bare lot value of that property, $8,900. So once again, the cost of demolition were in excess of the bare lot value. So there was no economic benefit to be realized on the demolition of these properties. The city is relying on the statute so that it has marketable title, so that it has an opportunity to get this taken care of expeditiously rather than waiting for the property to go on tax sale, followed by the time period that the tax sale certificate holder must wait before they can file for a deed, and assuming that the tax sale certificate holder even wants to get a deed. They have 3 years to exercise that right, and in some cases, if it's a nuisance property, they may or may not want to exercise that right. We just don't know. So this court recognized in Waterloo versus Bainbridge that if the city could not obtain clear title, the city would have little incentive to take the property. And really, that's the case here. This has been an important statute. City of Eagle Grove and other small towns in Iowa have utilized it for the benefit of their communities. We ask that the court reverse the district court decision and award title to the City of Eagle Grove. Thank you, Your Honors.
Thank you, Counsel. The City of Eagle Grove case is now then submitted to the court.